All right. So people are coming on in. Hey everyone, we'll start in a minute. Sorry, we were a little late. We had a technical issue. All right, looks like a good number of people flew in here right away.
Great. How are we doing time-wise?
We're a little late, but let's say we'll give it one more minute since there's still some people joining.
Okay.
And while we're waiting, folks, if you have questions, you can type them in the chat on the bottom, and I'll help run them to make sure that Greg gets them. I'll probably wait for the questions till the end, right, Greg? But
makes sense.
Yeah, people can ask them at any point, though.
Right.
All right, let's give it till 8 after, and then let's start.
All right.
We've got 60 people here.
Terrific.
Okay, I've got 8 after. You want to take it away?
All right. Well, hello, everyone. Appreciate you taking the time to be here this evening. Welcome to this May version of the Move to Amend monthly webinar. The theme this evening, subject is how to talk about corporate constitutional rights, aka corporate personhood. So glad you are a part of this gathering this evening. And as Caitlin may have mentioned, if you heard before, please at any time feel free to ask your questions via chat, which is located at the bottom of your screen, hopefully. And we will then take them on at the end of what will hopefully be a rather short, succinct, but hopefully broad and deep examination of this whole arena. So let us begin. Participation tips is you hopefully are hearing audio now. So turn up your computer speakers if you are not able to hear me as loudly as you would like, or if you have problems, you may want to jot down these numbers. And if you get cut off, call in using that webinar ID. Again, type your questions, chat bar at the bottom, and a recording will be emailed to all registrants after the webinar. All right, so the agenda for this evening is a quick overview of Move to Amend. What are corporate constitutional rights, aka corporate personhood? Quick examination and sharing of resources from Move to Amend National on this topic that we've developed, as well as then some ideas for how you can take action to end corporate constitutional rights, followed by questions and answers. The mission of Move to Amend, as many of you may know, if you are connected to us in any way, shape, or form, is that we are an outfit, a coalition of hundreds of organizations and well over 460,000 individuals committed to social economic justice, ending corporate rule, building a vibrant democracy that is genuinely accountable to we the people and not in any way, shape, or form corporate interests. We are seeking to pass the We the People Amendment in both the House, Senate, and then confirmed by the states to make clear that artificial entities do not have constitutional rights and that money is not a form of protected constitutional First Amendment free speech. We also have a goal of provoking discussion and organizing about how to make real the promise of democracy through constitutional renewal. We have these principles, basic ones of anti-oppression and solidarity organizing, which helps us develop relationships with those on the front lines of struggle against the impacts of corporate rule. Coalition and movement building, which we believe is extremely essential to connecting numerous issue communities to the legal roadblocks of corporate constitutional rights and money is protected free speech. Grassroots organizing is the key to building capacity, to building the power to bring about change, which is absolutely essential. Dedication to political education, that's what this session is about, and again, is something that is not only essential, but must be ongoing to understand what has happened in the past, to learn from history, to learn from what's going on in the present as well, the successes and failures of past people's movements as we build our people's movement. And finally, a goal of political and economic independence. We must be. They go together. They're inextricably connected. We have to be both politically and economically independent from the super rich, from big foundations, super duper big foundations, government, political parties, corporate entities, you name it. Our coalition structure is that we have a leadership team, a national board, very diverse from all over with rich experience in many different movements and issue areas, a national staff that we'd love to have larger than it is, but we make incredible do with what we have in reaching out both nationally and locally to work with affiliates, work with amendment working groups, work with coalition partners and independent supporters. It's the local affiliates who are the real backbone of what we do in trying to build a movement from the bottom up. Amendment working groups are those groups that may be doing other things, but one of their projects may be trying to promote the Move to Amend movement and We the People agenda, and would love to connect in that kind of solidarity way. And then there are completely independent coalition partner groups and independent supporters that work with us as need be, and always looking for ways to develop solidarity with those groups. We believe that We the People Amendment is absolutely essential for all the other issues that so many people care about, and maybe many of you are working on. That the truth is corporations have hijacked our Constitution and are working with the judiciary to use it against us, and are doing a fantastic job in doing so. The Green New Deal, Medicare for All, H.R. 1, the We the People or Free the People Act, which contains a variety of democratic reforms, ethical changes, and other approaches. Environmental policies, consumer protections, worker protections, all of these require dealing with corporate constitutional rights to really get to first base, let alone to get around the bases. And so that's why working with other groups to lift up these issues, but also help them understand that a parallel track is to work on ending corporate constitutional rights is so essential. We believe that the problems facing us is not simply a money and politics fundamental crisis, but at root, a constitutional democracy crisis. This next couple of years, this year and next, we believe are critical for the fight to save literally our planet. Without democratic governance, the legal authority to self-govern, to decide, is just simply essential. Otherwise, we will not be able to achieve the lasting fundamental changes required. And many, truth be told, that many members of Congress don't simply understand the depth of this issue. They may fake it and do a good job at giving the impression that they understand that the problem is more than Citizens United or getting big money out of elections, but they really don't get it. And that's where we come in, and that's where you come in to help them get on the other side of that learning curve. All right. So we begin with, if we're talking about corporate constitutional rights, let's talk about rights. Rights are basically a moral or legal entitlement to have or obtain something. We oftentimes hear the term inalienable or unalienable. They're used interchangeably and is defined as that which fundamentally cannot be taken away, denied, repudiated, transferred. These are considered to be things that are so fundamental that they exist by way of birth. And the definition of what those fundamental, inalienable, or unalienable rights are basically are based on cultures, countries, We, in the West, look at fundamental, inalienable, unalienable rights as things having to do with more political rights. Countries in the East, those that are quote unquote more socialist, have oftentimes defined fundamental, inalienable, unalienable rights as economic rights having to do with rights of housing and education and the like. But however you define them, and we think they should be both political and economic. A human right is a right intended exclusively for human persons. A constitutional right is a prerogative or a duty, a power or a restraint of power, and or a legal affirmation of an inalienable right that, quite frankly, is established by a state or nation that's sovereign, or a union of states, like the European Union, that acknowledges those rights and includes it in their constitution. The U.S. Constitution and rights, there were a few things in the original Constitution that were pretty darn good, revolutionary, in fact. The no granting of nobility, we the people are sovereign, no religious test for office or public trust, the authority to coin money, habeas corpus shall not be suspended, government guaranteed each state will have a Republican form of government. Those are pretty darn good, but there were some severe limitations that we are still struggling with and grappling with today. And one of the more fundamental ones is from the get-go, from day one, a limited sense of what constituted human personhood rights. White male property owners, that of 5 to 8% of the population were true persons. So a big problem right from the get-go. Another problem, basic, fundamental, profound, is that the Constitution affirmed property rights over human rights. And because of that problem, fundamentally from the start, much of the history that we have witnessed and are still witnessing and are a part of is one, both in the past and in the present, in which people are striving for rights via social movements, democracy movements that were not originally affirmed or granted. U.S. Constitution, we the people and corporations. Corporate entities are not mentioned in the U.S. Constitution, thus they have no legal foundation. The revolution was in part, the colonial revolution, a revolution against crown, what were called crown corporate entities, Massachusetts Bay Company, Carolina Company, and the rest, as well as the East India Company, which, as many people said, supplied refreshments for the Boston Tea Party. Corporations were created, defined by we the people, and public officials via charters or licenses that were granted and revoked based on what we the people at that time considered to be basic terms that were important for a company that was chartered to build a road or whatever. And this was the intention, the norm, the given, that we the people and those we elect, we do the defining, we do the authorizing, we're in charge, we're sovereign. Corporate entities, creations of the state only do what they agree is the terms in the charter. And if they can agree to it, great. If not, so be it. They can't have that legal protection. And when they violated the terms of the charter, as we the people established, those charters were revoked either by the state legislature or the courts. Here's just one of literally scores of examples just in the state of Ohio, where I've done some legal research, but similar charter revocations occurred in many other states around the country. And you can just read from that language. This is pretty self-governing stuff in which we, the people, understood our appropriate relationship between us and those entities that we create. The time has not yet arrived when the created is greater than the creator. We don't negotiate with those creations we create. We don't request, we don't plead, we don't ask, we authorize, we demand, we instruct. That's what self-governing people do. All right, well, corporations escape democratic control. They didn't take in democratic, of course, is in parentheses because it was relative. Again, only white male property owners, but the degree to which we controlled and defined corporations were pretty stringent. Corporate entities didn't particularly like this, so they figured out 3 strategies to escape democratic control. First is they worked at shifting decision-making to define corporate entities from the state to the federal level. So they sought to preempt and have federal laws that would overturn state laws that were, in many cases, more rigid. Monopolies is a good example. They secondly worked to shift decision-making to define corporate entities from the legislative to the regulatory arena. Here, regulatory agencies, including the first one, the Interstate Commerce Commission, was actually something created with the blessing of corporate entities because, hey, being regulated, a regulated monopoly that has profits that are guaranteed ain't too bad, and plus a regulated monopoly sure beats public ownership of railroads or water companies or other forms of entities. So why not? And thirdly, corporations shifted decision-making to define corporate entities from the legislative to the judicial arena, to the courts. And this is the beginning of how corporations were granted these bizarre constitutional things that we call constitutional rights that were never intended for them. And eureka, there you have it. The creation literally out of thin air of this sense of corporate personhood. And if you will, think of it in terms of like a castle that corporations were able to shield themselves, move from the, relatively speaking, democratic arena of the legislative, where we the people have at least some kind of input, to the judicial arena where we don't have much input. We don't have the ability to define, to authorize, to shape, to form. It's like they've gone in a castle and it's surrounded by a moat, and that moat is infested with alligators. Forget about trying to have any kind of influence. All we can do is be on the other side of that moat and cheer or boo, but we're not on the field. We're not inside that castle. We're not seated on around the table making the decision about what our democracy is going to look like. And as they say, if you are not seated around the table making the decision, then you are probably on the menu. And that is what has happened for the last 150 years, if not longer. Corporate constitutional rights weren't originally intended, not inevitable. It's not like gravity. It's not like the tides. It's not irreversible. Not created by any past law or regulation passed by any elected official, Democrat, Republican, Libertarian, Green, Red, any color, or by citizen initiative. Rather, they were consciously planned efforts by corporate attorneys and activist judges. And so this is how they did it. Corporations hijacked the U.S. Constitution. And they did it sort of these two ways. Corporations have hijacked the Constitution. They've been granted constitutional amendment rights, and they've used, misused, abused provisions of the original Constitution, with the effect that these rights and abuses have harmed you, your family, your community, your environment, and your democracy. And when we mean corporate entities, we mean not just business for-profit corporations, but also non-for-profit corporations, as well as many, but not all, unions. So here are the assumptions that we go by, and there can be others, but here's the ones that I think are important when thinking about, when approaching corporate constitutional rights, aka corporate personhood. One, corporate constitutional rights impact more than simply elections. Two, there's a negative influence of corporations beyond money in elections. Three, political elections are not the only arena affected by corporate constitutional rights. Maybe at this point you're sort of getting a drift of where this is headed. And four, political free speech rights are just one of many threats to we the people's legal authority to self-governance. Quite honestly, these are four different ways to say the same bloody thing. And our challenge maybe is not just to say the same thing in these four ways, but think of some other ways. And why we need to do so is because most people out there, most people that come to this issue, even, sad to say, a lot of people are connected to what we're trying to do, still don't appreciate. And hopefully after this and getting access to some of our resources, people will understand, and certainly the public at large, based on what you're going to do after this webinar in going out and spreading the good news about the effort to end corporate constitutional rights, is help people understand that corporate constitutional rights is more than simply elections and any of the other ways that are mentioned here and others that you can come up with. Business corporations don't need constitutional rights. A corporation is a vehicle to accumulate capital and do business. State law, which are called statutory rights, they already protect the legitimate functions of corporations in a variety of ways that, are legitimate reasons, rights, protections, abilities to act as one entity, to transact business, to own property, to sue and be sued in a court of law, and to enter into contracts. Those are important, but those kinds of, whatever you want to call them, protections, rights, abilities, none of those functions require constitutional rights. And Move to Amend doesn't object to any of these. The We the People Amendment would not change any of those. Those are called statutory rights. We the People Amendment addresses solely and exclusively constitutional rights, which are more powerful than statutory rights and have legal priority over them, which is why we are addressing those. Modern corporations exist as much as anything to make as much money as possible. They have used this money to buy political power that often defies the will of the people. And when courts give constitutional rights to a corporation, they are giving constitutional rights to property, not people, which means they've got more power and we, the people, have less power. A big, big problem. All right, so let's get into what we mean by corporate hijacking, constitutional amendments, beginning with the First Amendment. And it's not just one part of the First Amendment. There are several pieces of the First Amendment. The first piece of it that, again, most people are familiar with, and then, quite honestly, most people believe this is where corporate constitutional rights begin and, quite frankly, where they end, having to do with political free speech. Part of the impetus and backbone and underlying of this is a Supreme Court decision that affects corporate constitutional free speech rights, but also the free speech rights of money in elections from well-to-do people. And that's a 1976 Buckley versus Vallejo decision that equated money with free speech. Money spent in elections is free speech, political is free speech, and we all know, you probably heard in many ways, shapes, or form, if money is speech, those who have the most money then have the most speech. Not a real good definition of democracy. 1978, this is really the first time that corporations win never intended corporate political free speech rights. First National Bank of Boston versus Bellotti, in which the Supreme Court reversed a Massachusetts state law prohibiting corporations from spending money to influence legislation unrelated to their business. Here's the funny thing, and here's the ironic thing. This decision that we are all familiar with, Citizens United versus FEC, coming up next year, the 10th anniversary of which, wasn't really based on either the doctrine of corporate personhood or money is free speech. It certainly expanded the ability for corporations to use money as speech and for well-to-do people to use money as speech, but didn't really, it wasn't really based on either of them, but rather on these two weird things. One, the right of persons to listen to speech, regardless of the source. That's what was argued before the court, and that the corporation simply is an association of people with collective free speech rights. So that was the argument made, and that's what was decided by the courts. So the decision certainly allowed direct spending on elections by corporate entities. No longer did they have to have, these front entities called political action committees. They could spend money directly on creating these, hit ads and the like, and creating and resulting in an incredible amount of money being spent from corporations, super rich, and foreign entities to create all these dark money, super PACs, dark money, 501c4 organizations, and other entities that were used, so long as they didn't use the magic words of vote for, vote against, they could just flood the electoral process, flood the airwaves, flood our mailboxes with these ads, which they had done and continue to do very effectively. The impact of corporate political free speech rights are all the things that we have seen and witnessed and been victims of. The incredible amount of spending on elections, in which we believe that donations or contributions or investments are actually a form of legalized bribery, or whatever you want to call it, capital punishment. If you don't have capital, you will be punished, particularly in the marketplace, and of course all of the political marketplace, and of course all of this dark money that came into the political sphere. The flood of money from corporations as well as from wealthy individuals, the impact of corporate political free speech in elections is a major factor in all these sorts of things that we have been sort of at the short end of, in which deciding what issues are publicly discussed, how these issues are discussed, whose interests are heard and not heard, who gets elected, and of course ignoring all of these problems and solutions that are critical right now where we are in this point in our history. Problems in solutions affecting low-income working people, working class, people of color, other historically oppressed constituencies, dealing with the existential environmental crisis, and of course, maybe at root, most importantly, is the crisis associated with what's left, to what extent we ever had an authentic, legal democracy caused by big money in elections and corporate constitutional rights. All right, so that's the impact of corporate political free speech. But here's the other part of the First Amendment that corporations have hijacked that most people are unaware of. Non-political free speech, one of which is the right not to speak. One of these cases goes back to 1974, a Florida state law granting political candidates the right to equate to equal space to respond to criticism by a newspaper of their record. So these candidates thought they should have equal time. Well, the courts decided and determined otherwise and ruled in favor of the paper based on their constitutional rights not to speak. You've had New York state law in the mid-1970s in the energy crisis, banning, so this was a state law, banning all utility corporations from promoting the use of electricity in advertisements. Seems like a pretty fair kind of thing. When you have an energy crisis saying, you know, you're a regulated monopoly, we should have the right to say, sorry, you can't work at trying to promote greater energy usage, particularly at this point in time. Sorry, corporations went to court and said, you can't do that, that's violating my commercial speech rights. And the courts agreed in that 1980 decision. Supreme Court decided in the Pacific Gas and Electric Corporation that they weren't required to allow a ratepayer organization to include counter information to the corporations on issues in their billing envelope. Again, a registered, regulated monopoly. You would think we, the people, through the regulatory agency, should have the right to say, okay, we're regulating you. We're going to allow people to put information in the bill you send out to all your customers every month. Sorry. The court ruled that the corporation has a right not to speak, and one of my favorite terms of all time, with a straight face, the court said the corporation has a freedom of mind. Love that one. Another non-political free speech, those silly people in Vermont actually felt that they could have the right to label products containing bovine growth hormones based on, they think, the consumer's right to know what's in the food. Well, corporations went to court and said that they should have the constitutional right not to speak, sort of not to incriminate themselves, although they argued all along the bovine growth hormones was perfectly safe. The court, a lower court, it never did go to the Supreme Court, ruled in their favor, political right not to speak. Lastly, the Supreme Court recognized a for-profit corporation's claim of religious belief. So First Amendment has a variety of different aspects, as you may know, one of which is a right to religion. And so this was the corporation's claim of religious belief under the Religious Freedom Restoration Act. The decision permitted the corporation to deny contraceptive healthcare coverage to female employees. However, the decision didn't cross the line to say that corporations are protected by the free exercise of religion under the First Amendment, but it came pretty darn close and has certainly set a precedent for crossing that line, for saying that corporations do, and again, not the owner of Hobby Lobby Corporation, but Hobby Lobby Corporation itself had this religious right to deny, under the Religious Freedom Restoration Act, contraceptive coverage to female employees. So all of this is setting a precedent, which again, you can eliminate tomorrow morning. We could wake up and Buckley versus Vallejo is gone. Citizens United is history, and it wouldn't touch any of what we have just talked about, nor any of what we're going to talk about next, including, here we are. These aren't just sort of ancient decisions of the past, but here we are, current issues related to climate change and the lawsuits that are being leveled against ExxonMobil Corporation for its claim that it has been sitting on information for decades, knowledge that it had for decades, pre-knowledge of the impact and the connection between the burning of fossil fuels and the destruction of the environment. So people are trying to get at that information to hold them accountable. Corporations, Exxon Corporation, have gone to court and say, nope, we should not be able and not be permitted, and we should not be able to limit that because of our free speech rights. Again, Monsanto Corporation, same thing. They are claiming that they shouldn't have the right to, or they shouldn't have the power or the ability, or they should be able to protect their right not to release information concerning glyphosate, which is the key ingredient in Ready Roundup. And I've seen a couple of those authors of this article on Common Dreams you just might recognize there. Caitlin Sapoki Belknap, I seem to have heard about at some point, and Alfonso is an intern with Move to Amend as well. So non-political free speech is something in the news even in the present. Commercial, negative free speech, religious rights represent other aspects of the First Amendment that have been used by corporate entities or misused to defy the legitimate rights of people to know factual information, to prevent corporations from being held accountable, to the provision of basic health needs of employees, and the authority of government to protect the health, safety, and welfare of residents. Fourth Amendment, so it's another, not just First Amendment. Fourth Amendment, search and seizure. Fourth Amendment talks about the right of the people to be protected from right of privacy, including protection against unreasonable searches and seizures. Well, back in 1906, that was the first case. Prior to this case, corporations didn't have privacy protections. Many corporate charters stipulated that books and records of corporations had to be transparent to ensure public accountability. In my state of Ohio, where I live, this took the example of a bank, many banking corporations, and I can't quite understand why people would be so concerned about banks. Once a month, had to make available in the public lobby their books for public inspection once a day for that month. Pretty cool. Corporate hijacking of the Fourth Amendment. This was maybe one of the more famous or infamous decisions, Marshall versus Barlow, 1978, where a surprise inspection of business premises was prohibited. Here, OSHA inspectors tried to do a routine inspection of this plumbing and electrical business. The company president said, nope, you don't have a warrant. OSHA went to court. The Secretary of Labor said, hey, we can do that. We have a right to search and inspect for safety hazards and violations because of Section 8A of the OSHA Act. Well, the Supreme Court didn't agree and ruled that that was unconstitutional because it authorized inspections without a warrant. And so here, this represents, and many other cases have occurred since, that governmental attempts to protect the public from a myriad of dangers stemming from private commercial activities, from food contamination, drug impurities, auto defects, environmental hazards, and others are thwarted by removing the advantage of surprise inspections, thus allowing businesses to hide, alter, or disguise dangerous conditions. And in his dissent of Hale versus Henkel, a Supreme Court Justice Harlan said, the power of government by its representatives to look into the books, records, and papers of a corporation or of its own creations to ascertain whether that corporation is obeyed or is defined, the law will be greatly curtailed, if not destroyed. And so here we are. These are current examples. The Enron scandal, in which Enron kept from the public huge debts off its balance sheets that resulted in thousands of employees, losing their retirement and or their jobs, and our friends over at Wells Fargo creating all these literally millions of fake accounts and deposits. Imagine if we had had search and seizure rights, Fourth Amendment, we might have been able to nip in the bud some of these problems. But of course, the opposite doesn't hold true, where our individual search and seizure rights aren't protected these days because of, in essence, the power of corporations to use information that we present to them and share with them through our cell phones, GPS following, or through Facebook, or Amazon, or Google, in selling to other parties what we do. So it's a real super duper double standard. All right, Fifth Amendment, takings rights. Among its many provisions of the Fifth Amendment is the provision of, nor shall private property be taken for public use without just compensation. This is what's called eminent domain, that yes, the government can take private property from you, but it's got to be for public use, number one, and you have to be justly compensated. But that only applied supposedly initially in the Constitution in the Fifth Amendment to individual property. Corporations argued that it should apply to them. In this decision, Pennsylvania Coal Company versus Mahon, 1922, in which a state statute, a state law in Pennsylvania preventing the sinking from underground mining was struck down. So people who felt that the mining of coal underneath their homes should be regulated, if not outright prevented, but at least regulated to make sure that there wasn't a sufficient amount of coal taken out so as to prevent their homes from being sunk, should be held valid. Well, the state or the corporation went to court and said no. To do that would be an unnecessary taking, meaning that if you want to do that, okay, but you will have to compensate us for the value of lost profits, with even in 1922 would amount to millions of dollars. So basically the result of that decision is that it invalidated what's called the state's police power. This is a basic fundamental power and right that states and many municipalities have to protect the public health, safety, and welfare of their residents. And that police power is that which is used widely and deeply to protect the public health, safety, and morality, without which, why do we even have, there's really not much reason to have municipal government or state government if they're not going to have that ability to protect their own residents against these outside abuses coming from outside their states. And the impact, and just think of the implications of that right now on just one issue related to the existential climate crisis. Any democratic decision to ban oil and gas development to save what's left of our climate may constitute a taking. And corporations, oil and gas companies, will no doubt go to court demanding compensation for current and or future profits lost. This could cost literally trillions of dollars. Corporate rights in that case would preempt the rights of human beings to protect what's left of the planet's climate. So legally mandated compensation of lost, present, and future corporate profits deters. It creates a chilling effect, in essence, of the passage of democratically enacted regulatory laws protecting public health, safety, and welfare. You can bet that anything that gets serious along the lines, passing the Green New Deal, if it makes it that far, if you can get it through Congress, there's always that backstop in which the corporate desperados will go to court, and among their anti-democratic weapons surely will be the Fifth Amendment takings clause. Fourth Amendment, the hits just keep on coming, folks. The corporate hijacking of the 14th Amendment, this pertains to equal protection and due process. There were other provisions of the 14th Amendment. These were the two most relevant to corporate constitutional rights, and it's a fiction, as many of you know. The corporation of constitutional rights, it arose out of a court reporter's false unofficial comment that the Supreme Court had given corporations the same rights as natural persons in this Supreme Court decision of Santa Clara versus Southern Pacific. But comments, the unofficial comments given in the beginning of a case, the head notes is what it's called, has no legal validity. The court's decision, however, made no such ruling. In fact, the court, in its decision, explicitly ruled they would not decide the constitutional question because the case could be, and in fact was, decided on other grounds. But nevertheless, the 14th Amendment, while it did not mention corporations giving them the constitutional rights of persons, the Supreme Court said, in essence, that it did. However, the court has never explained or justified in any decision why an artificial person like a corporation should have the same constitutional rights as natural persons. In every case, granted constitutional rights based on Santa Clara rests on this unsupported falsehood. But yet it's become a precedent for cover for literally scores of decisions, everything from the Minnesota and Santa Clara Railroad case, 1889, to all the ones up to the present, that has served as sort of the anchor or the building blocks on which all of these other 14th Amendment cases have stood. And yet, all the cases, many of them for the first 50 years, as Justice Hugo Black said, more than 50% early on in the first 50 years pertain not to the 14th Amendment applying to freed black slaves, which is what was intended, but corporate entities. And the Lochner case in 1905 basically sparked similar decision. This decision basically, which resulted in what was called substantive due process related to the bakery industry. Basically, what it resulted in this case is the invalidation of several hundred federal and state corporate-related laws and regulations protecting workers, including children, consumers, and communities. The Liggett case in 1933, state of Florida passed a law that levied higher taxes on chain stores than locally owned stores. Sorry, the Supreme Court said that violated the Due Process Equal Protection Clause of the 14th Amendment. And again, let's be mindful, this has nothing at all to do with First Amendment free speech rights having to do with money in elections by corporations. Nothing. Buckley versus Vallejo could be gone. Bilotti could be overturned. Citizens United, a piece of history, it wouldn't affect this whatsoever. How corporate hijacking of this amendment harms you, your family, communities, and or the environment, all of these ways. It's favored local businesses over chain stores, opposed the siting of cell phone towers, even favoring family farms over agribusinesses have been overturned. So many states in the Midwest over the years have tried to pass citizen initiatives and have been successful in saying those who own the land can only work the land, trying to give preferential treatment to family farms. The agribusinesses have gone to court and said, sorry, you are discriminating against agribusinesses, and the courts have gone along, and thus making it much more difficult for family farms to sort of get a significant foothold. All right, and very quickly, it's not just hijacking the constitutional amendments, but also original sections of the Constitution, including the Commerce Clause, the basic provision being that Congress shall have the power, quote, to regulate commerce with foreign nations and among the several states and with the Indian tribes. Well, here you have seen, and here you see several examples in which various states have tried to pass laws that protect, in the first case, try to protect and call for the labeling of the health of the residents on meat products. And in the second case, trying to protect the water, groundwater from outside the state. And in both cases, the courts have overturned under the Commerce Clause, saying that both of those laws passed at the state level were a violation of the Commerce Clause. In this particular case in 1990, an effort to avoid, many cases are in this sort of realm, in which states try to prevent the out-of-state dumping of hazardous waste coming into the community, in which the state says that is a form of waste. But the corporations say that no, that is not hazardous waste, but rather that is a commercial product. And the Supreme Court, by looking at this, okay, whose rights and whose way, whose lens are they going to look through? Is it going to be the state lens that no, this is a waste product that presents a form of hazardous waste? And of course, the police power allows communities to protect the health, safety, and welfare. Or are they going to look at it through the lens of it's a form of commerce under the Commerce Clause? And the Supreme Court oftentimes has gone the way of corporations and have said that this instance of waste, and in many cases, dozens of cases, that it's overturned, and you as a state, you as a community are forced to accept this hazardous waste material because it is commerce. And there's just been so many instances of abuse of the Commerce Clause. This is sort of the way they have done it, the way they've overturned it, this process, the sequence that they've followed to overturn it, in which a local community tries to pass a law, the corporations go and challenge it in court. The agents say, no, it's a trade barrier, it's a form of commerce. The court agrees, the law is overturned, corporations gain greater political, economic rights, and we lose as a people and as the public to protect and basically have the right to decide. Our ability, our right to decide is preempted, or no pun intended, trumped by the corporate ability to protect its rights and expand its profits. Finally, the abuse, misuse, and abuse of the Contracts Clause. Here, Dartmouth College versus Woodward is an instance in which states are not to interfere with private contracts, originally between individuals or between the state and individuals. Here, the original, as we learned before, The charter was a democratic defining instrument. And that was how we, the people, controlled corporate entities. This sort of took some of the power away from that. If you define a corporation as a contract, if you define a charter as a contract, then it's sort of a relationship not of superior versus subordinate, but of equal parties. And equal parties, you can't order me, you can't tell me, you can't instruct me what to do, but rather we're sort of even Steven here. There's only so far you can go without me challenging you. And that limited from that day on, going all the way back from beginning in 1919, the power that states had in using the charter to fundamentally define what corporations could not do. All right, very quickly, to run through the rest of this. Here's a number of resources, and we'll follow up by sending everyone who's on this call or who have signed up to be on this webinar a list with links of what we have and what we produce. And these are just some of the resources. The Legalized Democracy film delves into many corporate constitutional rights. This series that we have just developed, Corporate Hijacking of the U.S. Constitution, in which we have an overall 4-page piece called How Corporate Constitutional Rights Harms You, Your Family, etc., as well as a 2-page individual pieces on how the corporations hijack the First Amendment, both political free speech and right not to speak, as well as the 4th, 5th, 14th Commerce and Contracts Clause. All of those are available. They're online. We'll send you the link. We have a timeline of personhood, rights, and powers. We developed a rights and privilege timeline exercise that's really great for your group, perfect for the upcoming Constitution Day in September and other usages. There's a 2-page, 1-page actually, corporate constitutional rights, key non-First Amendment right to speak, Supreme Court decision piece. And just recently we've developed a 2-page side-by-side comparison that looks at the Move to Amend, We the People Amendment, HJR 48, and the Democracy for All Amendment, HJR 2. Ending corporate constitutional rights and corporate personhood. Some years ago, ran into this quote by an engineering department professor at Yale University, in which he said, quote, "If I had only an hour to solve a problem, I would spend up to 2/3 of that hour in attempting to define what the problem is. The truth is, though, that most individuals have not taken the sufficient time or been exposed to the right information to understand the democratic threat, to authentic self-governance posed by corporate constitutional rights. Thus, they define the problem post-Citizens United as all of this, as, well, there's no transparency of money in elections. The problem is big money in elections, or corporate money in elections, or elections, but not that the fundamental problem is, yeah, money in elections, but also the sum total of corporate constitutional rights. We've got to do what we can to include that. And thus, ending corporate constitutional rights and corporate personhood. No decree, regulation, or law is sufficient. No election of any public official is efficient. Not simply about corporate united cursing, nor even Buckley versus Vallejo reversing. The only way to set our sights to abolish corporate constitutional rights is a constitutional amendment to end corporate personhood. A big step toward making our government good. And the only, thus, proposed constitutional amendment that is great is, we believe, the We the People Amendment, HJR 48. So, take action. Here's what you can do to weigh in and do your part to end corporate personhood, as basically is, the keys to working on anything we work on, right? It's to educate, to advocate, and to organize. To educate, we got to get on the other side of the learning curve about corporate constitutional rights. It's more than just simply political money in elections, and thus we are called to study, to learn, to share, to discuss. Take the time, immerse yourself in this stuff. The truth of the matter is, you now know more than I can probably guarantee it, 98% of Congress people in Congress. So part of the charge is to learn this stuff, get a handle on it, and share it with people you know, people you may not know, but also your Congress person. That sort of gets into advocate for the We the People Amendment. So ask your congressperson to co-sponsor HJR 48, join what's called Free the People from Corporate Rule. May 28th Day of Action. We'll send out a link if you aren't aware of what that is. You can participate if one's already planned in your community. And ask your state elected officials to pledge to amend. That's where they sign up to do what they can as a state official, to do what they can to endorse a constitutional amendment, to support it if it comes their way, to share it, to introduce a resolution in city council or at the state level, whatever the case may be. And finally, to organize. Not just to join a Free the People from Corporate Rule Day of Action, but if you are so inclined, to organize one. To start a Move to Amend affiliate group or join one near you, to join a Move to Amend as a partner group, to seek endorsements from groups, from municipalities, to ask your municipality to pass a resolution, or to become part of an effort to get a citizen initiative on the ballot. And finally, to help us become politically and economically, and they go together. Remember, at one time, politics and economics, political economy was one. They artificially were divided. They go together. The only way we can be as a sustainable movement is to be politically and economically, they jointly go together, independent and sustainable, by doing what you can, whatever that is, to contribute to Move to Amend. Thank you for helping us in whatever way. And if you're already a supporter, endorser, contributor monthly, thank you. If you aren't, please consider doing so. Or if you can't, at least make a contribution one time. I apologize for running through so fast. Sorry about it, but this will be up and it will be recorded so you can go back and listen again. At this point, I will take a sip of water and open it up for questions, comments, queries, consternations, whatever the case may be. Thanks.
Okay, thanks, Greg. So you can type your questions in the chat. I can also see your Q&A if you want to use the tool that it offers there. So let's see. Why don't you keep that up there, Greg, and I'll just do these
okay.
for you. So a few people talked about how there's a lot of information here. And again, we will make sure that you can get the recording and the slides so that you can use them and go through them more slowly. But Mary Sue is asking, what do you find the most effective elevator speech on corporate constitutional rights, to just kind of get to it in a nutshell?
Well, when I say elevator speech, and those who have gone out and done initiatives to get something on the ballot, they basically only have an elevator speech time, or on the, on the streets. Basically, hey, these corporations aren't mentioned in the Constitution. They were not intended to have rights. It's not how it once was. It's not how it was meant to be. They are artificial creations of the state. Without a state, you couldn't have a corporation. We at one time defined, we authorized what they could and could not do. And in a sense, what our We the People amendment is calling for is, in a sense, going back, shifting back to what at one time was the case, which was we were, through the charter, defining what a company cannot do. That's what we're calling for once again. And what exists now is basically a dramatic, extreme departure that occurred through activist judges, and your public official, be it Democrat or Republican at the local, state, or federal level, never, ever passed any law or regulation that gave corporations constitutional rights. That only happened out of thin air by activist Supreme Court judges. What do you think of that?
That sounds good. If anybody has any follow-up on that, feel free. Let's see. Rob is asking, so is the underlying issue the lack of a definition of person in the Constitution?
Well, I would say that certainly is maybe a part of it, in that a person could have been defined more explicitly, but it was clear enough. I mean, in terms of that, it should have been made more explicit in terms of all people, regardless of race, regardless of gender, regardless of nationality, regardless of ownership of property. That would have been more explicit, certainly, so that those individuals, those constituencies that spent literally years, if not decades, organizing social movements to drive themselves into the Constitution where they should have been all along, wouldn't have had to do that. But I thought, and I think it was pretty explicit from the get-go that it only pertained to natural persons, and that a corporation is not a natural, that it is not a person. And given that many of the founders, while they screwed up in a lot of ways, they had fought a revolution against the crown corporations and the British East India Company, it was pretty clear that the context for writing what a person was may have been imperfect and was very imperfect when it came to human beings, but when it came to artificial beings, quote unquote, I think it was pretty clear.
Yeah, and I think that also now with the, recognition that nature potentially deserves and needs some rights, and then also the, I don't know, just the racism. I would say that we kind of want to stay away from saying this is a person and this is not a person, but rather just making clear that corporations and artificial entities are not people.
Yeah.
Do not have.
Yeah, the whole thing about nature, to equate nature with people, I think they have rights, whether it's, I don't know whether they call personhood rights. So there's some work we need to do on that and some thinking that's going on elsewhere.
Yeah, part of that might be our own vocabulary and limitations.
Right.
But we certainly don't want to head off that question accidentally by trying to take on too much here with our amendment. Let's see, there's a couple other questions. William or Cody is asking, after we pass the We the People amendment, what happens to PACs?
Oh, I love that attitude. First of all, thank you, Cody. After we pass the amendment, absolutely, that is the appropriate approach. What happens to PACs? Well, what happens to PACs and what happens to money in elections and what happens to the ability of the relationship between we the people and corporations will, in a sense, be up to us, because all of that will be up for grabs and will become a democratic decision that, again, this is shifting the decision-making and the ability to define money in elections as well as corporations away from sort of that castle surrounded by the moat with alligators back into the democratic arena where we can enter it safely without being bitten by alligators, where we are seated around the table, where we're not on the menu, where we now are having that democratic discussion at a local, at a state, and a federal level about should we have PACs? Should we, limit amount of money and what that amount should be? Should there be any private money? Should it be all public money? Should there be free media advertising, which, we do happen to own the airwaves after all, and the airwaves are being used and misused right now by electronic corporations, radio and TV, and they're charging huge amounts of money, which in a sense drives companies and individuals to form PACs. PACs are almost, though, technically not needed post Citizens United, but all of that is basically moved back into the democratic arena where we can discuss now what should be the appropriate role, relationship, amount of money, if any amount of money, where we now can't discuss because of the shield, because of the running protection in the castle surrounded by the moat that is the corporate constitutional rights defined and affirmed and authorized and reinforced virtually every time a Supreme Court brings up a case. And all that will change.
Yeah, one of the ways that I talk about it is that the amendment basically provides a foundation, a democratic foundation upon which we can build up whatever legislation or changes we would like to see as it relates to PACs or election financing in general, or corporate ability to participate in different arenas that are not the economy, et cetera. So without that foundation, though, we have no ability to exercise democracy without the threat of the court overturning whatever we try to do. And so in and of itself, the amendment basically just makes that possible. It doesn't mean, anything in particular as it relates to, PACs or money in politics. That all can be determined after the amendment passes, and only when the amendment passes.
I lost you for a second. I don't know if you were still speaking, but
I think that was just because your thing was adjusting. So I think
okay, great.
There's a few more questions, or a little bit more time. I think we can take a few more questions. Let's see. I think we kind of already got to this one. Sorry about like what would it look like legally after the amendment is ratified. They're also, let's see, just want to make sure I'm not missing any. They're coming in different areas.
For listeners who may not, or viewers who may not know, part of this question, post 28th Amendment, is something we are already giving some planned and conscious discussion and thinking around. We have formed what is called a model corporate code working group that is grappling with what a post 28th Amendment world would look like, and taking up some areas and questions related to, what does lobbying look like? What might be the protections of labor unions? About cooperatives? What about some other arenas what about freedom of the press, because corporations do own the press? Some other examples like that are important to be given some thought to now, ahead of time, and not wait until the We the People Amendment passes.
Okay, so we've got two more questions that I see. Jim asks, philosophically, isn't the central issue that we need to be clear on what is public and what is appropriately private, how we define and manage the commons?
That is a good way to frame things. That which is public, that which is private. You can take all of these and sort of recategorize it in that way, in which we, the people, the institutions we create that are, relatively speaking, democratically created, are public, and those entities we create, including corporate entities, for-profit, those that we give license to, not-for-profit, even unions have a certain, if they want that charter, even now, or certain 28th Amendment, certain degree of publicness about that, and therefore we should have the right, the ability to define to a certain extent those institutions we create that are public, and they should not be able to hide behind the sphere of that which is private, that which is proprietary, that which is beyond the reach of we the people. So absolutely, that is an important frame.
Great. Yep. I agree that so much of the problem started when corporations were able to move into that private sphere instead of being understood to be, partly public because of the fact that we brought them into existence in the first place. So they kind of owe us and therefore never get to be private. One more question from David. Why is it so difficult to cancel/revoke corporate charters, the death sentence for corporations, as it were? Why can't we do that today?
Well, part of it is that, part of it is a cultural issue that we have been, I think, imbued by the corporate culture through the corporate media, that even when there are the Enrons of the world or the Wells Fargo, habitual criminals. All right, you want to deem a corporation a person. Some places have established a quote unquote 3 strikes and you're out, which I have a problem with in some cases. But even if you believe that's important and you think corporations is a person, there are some habitual violators. Shouldn't even in that instance a corporation lose their right to exist or be thrown in prison forever, which would in essence be the equivalent of losing their corporate charter. But we don't think that way because we're sort of led to believe that even those instances where you have corporations that are habitual criminals, Exxon, for Valdez, and many companies that have created these horrible repetitive influence, that the worst that can become, the worst punishment is a fine, is a temporary prohibition from getting a government contract, from being prevented from, buying or acquiring another company. But the corporate, if you will, death penalty is beyond what we are led to believe is an option, because to present that as an option, if the mainstream culture does that, then that might invite people to say, well, wait a second, how did that come to be in the first place? When did that arise? And you know what? Gee, maybe that is a much better deterrent than simply fining, simply, forestalling them giving a government contract. That's part of it. The other part is that corporate constitutional rights have sort of shielded the inability of states to go after corporations. So in part it's cultural, in part it's legal.
Okay, that looks like we've answered kind of the big ones. A number of people asking, if they can share this presentation and use it. So yes, we make it available on the website, and folks can use it as you need to. And if you've got any questions, follow up when you get the recording link and slide link. You're welcome to email us back. And I think we can be done tonight. Greg, and any last words you want to add in closing?
No, other than appreciate everyone who has stuck with this. Appreciate those of you who may be listening to this for the first time. There is only so much we at National Move to Amend can do in this realm. Produce some resources like this, some of those previously referenced, those on the website, but to get them out there. Again, there's some things we can do through the website, social media, going out to conferences and barnstorming and the like that you all are aware of. But again, to affirm and validate what we had said at the beginning, so much of what we are about is you. We're not powerful so much from the top down as we are from the bottom up. They do go hand in hand, but an important piece is from the bottom up. So do what you can. You are now in charge. You are now empowered to do what you can to share this information with others. Each one teach one. Please do what you can. Thanks.
Thanks so much, Greg. All right, everyone, stay tuned for the recording and the slides to come to you by email tomorrow, and have a great night. And next month, ooh, I should have been ready for this, but let me just say it now. Next month, we'll go back to the first Tuesday of the month, and our topic will be how to bird dog candidates and politicians to respond to your agenda. So I hope everyone will join us back then. Have a good night.